Acquisition and termination of Indian citizenship. The Indian Constitution does not define the term citizen but provides details of various categories of persons who are entitled to citizenship, which is embodied in Part 2 in Article 5 to 11. Citizenship is listed in the Union List. The Constitution empowers Parliament under Article 11 to pass laws and regulations about citizenship. The provisions regarding citizenship of India are enshrined in the Citizenship Act of 1955. The Citizenship Act of 1955 has been amended from time to time, like in 1986, 1987, 1992, 2003, 2005, 2016 and 2019. There are 5 ways of acquiring Indian citizenship. First, by birth. Section 3. A. A person born in India on or after 26 Jan 1950 but before 1st July 1987 is a citizen of India irrespective of the citizenship of parents. Amendment in 1986 changed the above provision. B. A person born in India on or after 1st July 1987 but before 3rd December 2004 is a citizen of India if either of the parents is a citizen of India at the time of birth. Amendment in 2003 changed the above provision. C. A person born in India on or after 3rd December 2004 is a citizen of India if both the parents are citizens of India at the time of birth, or at least one parent is a citizen and the other is not an illegal migrant at the time of birth. Section 21B of Citizenship Act 1955 explains migrant means without valid passport and valid travel document or stays beyond visa permit. In 2015 and 2016, 2 notifications were issued by the central government to exempt certain groups of illegal migrants from provisions of 1946 and 1920 Acts. These groups are Hindus, Sikhs, Buddhists, Jains, Parsis and Christians from Afghanistan, Bangladesh and Pakistan who arrived in India on or before December 31st, 2014. These groups of illegal migrants will not be deported or imprisoned for being in India without valid documents. The Citizenship Act 2016 brought the above 6 religions and 3 countries eligible for citizenship. Second, by descent. Section 4A. If a person is born outside India on or after 26 Jan 1950 but before 10th December 1992 is a citizen of India if the father is a citizen of India by birth. Amendment in 1992 changed the above provision. B. If a person is born outside India on or after 10th December 1992 but before 3rd December 2004 is a citizen of India if either of the parent is a citizen of India by birth. Amendment in 2003 changed the above provision. C. If a person born outside India on or after 3rd December 2004 is a citizen of India if parents declare the minor does not hold a passport of another country and the birth is registered at an Indian consulate within 1 year of birth. Third, by registration, Section 5, the Ministry of Home Affairs of the central government on application may register a person as a citizen of India if they belong to the following categories. A. If a person is of Indian origin who has been residing in India for 7 years before applying for registration. B. If a person is married to an Indian citizen and is residing in India for 7 years before applying for registration. C. If a person of Indian origin who is a resident in any country or place outside undivided India. Undivided India means except people from Pakistan and Bangladesh, all persons of Indian origin can be registered as overseas citizen of India. D. Minor children of Indian citizens. E. If a person of Indian origin who is a citizen in any country but residing in India for 7 years or in government service before applying for registration mentioned in the first schedule. Commonwealth countries, UK, Australia, Canada, New Zealand, Pakistan, Southern Rhodesia, Union of South Africa, and the Republic of Ireland. Fourth, by naturalization, Section 6, the central government, if satisfied that the applicant is qualified for naturalization under the provisions of the third schedule, may grant a certificate of naturalization. The qualifications for naturalization of a person are: A. A person should not be a subject of any country where Indians are prevented from being a citizen. B. A person has to renounce his already acquired citizenship for acquiring Indian citizenship. C. A person residing in India or in central government service for 12 months immediately preceding the date of application. D. During the period of 14 years prior to these 12 months, he has resided in India or been in central government services for not less than 11 years. E. A person should have adequate knowledge of a language specified in the 8th schedule. F. After grant of certificate of naturalization, the person should reside in India. If the applicant has rendered distinguished service in the field of science, philosophy, art, literature, world peace, or human progress, the central government may weigh all or any of the above conditions for naturalization. If the applicant belongs to any 6 religions and 3 countries, the 11-year requirement is relaxed to 6 years. Fifth, by addition or incorporation of territory, Section 7, if any foreign territory, state or state becomes a part of India, then the central government declares it as part of the Union of India by issuing in the official gazette. Territories of Goa, Sikkim, Puducherry, Daman and Diu became part of India, and their population became citizens of India. And in 2015, people in Indian enclaves in Bangladesh were given Indian citizenship after the land boundary agreement. Grounds of losing Indian citizenship. The Citizenship Act 1995 lays down the mode by which an Indian citizen may lose citizenship. The 3 ways are renunciation, termination, and deprivation. First, renunciation of citizenship, Section 8. An Indian citizen can renounce his Indian citizenship by a declaration to that effect, and the declaration has to be registered by the prescribed authority, and upon such registration the person ceases to be a citizen of India. But if such a declaration is made during war in which India is engaged, the registration is withheld until the central government otherwise directs. When a male person renounces citizenship, the minor child ceases to be an Indian citizen, but the child can resume Indian citizenship within a year of attaining 18 years. Second, termination of citizenship, Section 9. If an Indian citizen voluntarily acquires the citizenship of another country, they cease to be a citizen of India. During the war period, this provision does not apply to a citizen of India in which India is engaged. If the question arises as to when or how any person has acquired the citizenship of another country, it is determined by an authority as prescribed by rules. Third, deprivation of citizenship, Section 10. Deprivation means compulsory termination of citizenship of India. A citizen of India can be deprived of citizenship by an order of the central government if it is satisfied that A. The citizen has obtained the citizenship by means of fraud, false representation, or concealment of any material fact, or B. The citizen has shown disloyalty to the Constitution of India, or C. The citizen within 5 years after registration or naturalization has been imprisoned in any country for a term of not less than 2 years. D. The citizen has unlawfully traded or communicated with the enemy during war, or E. The citizen has been resident out of India for 7 years continuously.